All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in Settle against Settle, our cause number 1CA CV130650. Counsel, I'm sure you're aware that we've had an opportunity to confer about this case and read the briefs before coming in to court this morning, so you can bear that in mind as you begin your presentations, which will be videotaped. Each side has 20 minutes for oral argument, and the appellant obviously reserve as much time as you like for rebuttal, subject to watching your own clock. And with that, you may begin.
Morning. Keith, may it please the court, Keith Berkshire for the appellant, Doug Settle, who I'll refer to as father. Interestingly, about 2 to 3 weeks ago, there was an editorial in the New York Times called How Divorced Parents Lost Their Rights. And it was on this issue. It was sent to me by one of the custody evaluators that we use in this case, or that I've used previously. And it goes through this issue of rights that you'd have while married versus rights you have to pick activities while after a divorce. Frankly, as somebody who has 4 kids, this case terrifies me. It terrifies me that the thought that the court can intercede and deny me parenting time based on what I do with my children. I was thinking about this case this weekend while I was working on my Jeep with my oldest son, who's 11, when I chose to not take him to a sporting event that something he was involved in, instead stay home and help me do an engine swap on my Jeep. At the same time, my 6-year-old daughter was out there because she likes to hand me zip ties when I do electrical work. And the thought that the court can choose what activities I do or what activities I refuse to do individually because of what that judge thinks is acceptable activity and deny me parenting time based on that should scare this court to the level of interference that a trial judge can have in this case.
Counsel, let's go back and talk about denial of parenting time. Didn't your client agree to a very specific schedule that would be laid out for the next few years?
He did. And Judge, I think that brings up an important issue because this is one of the main things that in Appellee's brief that they bring up, that there was no substantial change of circumstance found. That was never found. The court, as anybody that goes from a significant change in parenting time, if we go under Owen v. Blackhawk or cases like that, when you go to equal parenting time, this implicates the ARS 25411 standard for a substantial change. That wasn't found in this case. The court didn't find there was
Owen v. Blackhawk and other cases, are there any other cases on the books where parents have agreed to a specific plan over future years?
A plan that contemplates substantial changes itself.
Well, and I understand that issue, Your Honor, but however, that wasn't what this court relied upon in denying the parenting time increase. The court didn't say, you didn't prove a substantial change, therefore we've done the gatekeeper function under 25411 and we're not going to hear it.
Understood, but did the court say this was a substantial change in circumstances? Did the court make that definitive finding?
They didn't
specifically.
They didn't say it either way. They did what they're supposed to once they get beyond that gatekeeper function of 25411 and Owen v. Blackhawk and Dorman, which they go through the 25403A factors. That's what they did. And so there was never an argument, or the court never specifically found no change, that he didn't prove he didn't prove a change, because remember, you have to find the change first before you go to the 403A factors. You don't have to go to the 403A factors if there's no change. You just simply say there's no change.
But wasn't a part of the court's consideration the fact that these people had, through the consent decree that had entered, they had stipulated to this circumstance, and there was no need to change that circumstance based upon what had been presented to the court? Isn't that what the court did?
The court used that as a factor, that the child was doing good under 25403A. That was one factor.
And that there was a consent decree that said,
correct,
we're going to abide by this fixed schedule.
Your client was the one looking for the change.
Correct. But again, I'd point out that the court didn't find that no change occurred. They went to the next step to use the 25403A factors. And let's face it, there has been a change. There's been the change in the law twice since this case since the original decree in this case. 25103, the public policy statement in 103 went into place, and even more recently, 2540302 changed it to a statement of more equal parenting time.
And if the court was if the court was being asked, absent the stipulation of the parties to determine this issue, those would have become relevant. In this case, there was a stipulation of the parties to a process, and your client was saying, I want you to set aside the stipulation we entered into. I want you to change what we both, I believe, my recollection is, went to an attorney and pounded out between us before this matter was entered as a decree by the court, a part of the decree by the court. So it's really not the same as saying there was a modification in front of him and he didn't apply changes in the law.
Well, but I think we have to look at what the court actually ruled, and specifically on page 4, the court finds, based on the above, it's the best interest of schedule to remain the same. But then it goes into the extracurricular activities. That's the part, and that was the majority of the court's ruling, was based on these extracurricular activities, that is why the change was not going to occur.
And that's an issue that we can certainly discuss, but you've sort of set this argument against the background of terror in the court, and we've raised a constitutional challenge to address that. I'm having trouble equating terror of the court with the notion that a person was unable to enlist the assistance of the court in getting out of his own agreement. How is that the court wielding this terrible unconstitutional power over parents?
Well, I don't think that the standard
Parenting plan here was chosen by the parents.
correct.
And there are only so many days in a week.
And since
So where's the judicial terror?
And since that case, we're talking about two different standards here, and a two-step process. That the first step is to find that a change occurs. And all the case law and modification says once you find a change has occurred, then you look at 403A anew. This is, you get past this step, it's a new case. It's
Okay,
like
so what's the
modifications.
change here?
The changes were illustrated in the petitions and the testimony. The changes were my client moved back within what he called throwing distance of mother's house, where he wasn't living there at the time that they were divorced. The change was the child is now 3 years older. That if we go through cases like Pridgeon,
the child was exactly the age that the consent agreement anticipated for the process that was then in place.
Understood. But however, we also have the fact that they're also now living closer. Both parties have new spouses and change of the social environment of the child.
Okay,
the standard for
you're suggesting that that beyond their ability to comprehend at the time they entered into this provision was the fact that they would remarry or might remarry, and that they might move closer to each other. Those were beyond their comprehension at the time that they entered into these provisions?
I don't think anything under the standard set forth for what a continuing change of circumstance is, that it has to be such a drastic change beyond any comprehension. Obviously, you could comprehend anything in this, anything could potentially happen. You could contemplate moving and so forth.
But it sounds like you're taking two sides of the same argument. On the one hand, the court should consider nuanced factors about changes in social environment and the distance between houses and all this stuff, and that should be very significant to the court in deciding whether to strike an agreement that the parents themselves freely made. But on the other hand, if the court takes social circumstances into account in making its decision, it's committing a constitutional violation worthy of the New York Times. And I'm struggling with the inconsistency there.
I think in and of itself, at the time that this was entered into, I could cite cases such as Edsel that talk about change in law is reason for modifications. This not only had one change in law, this had two substantial changes in law after they entered the decree. So any agreement my client entered into before the law changed that said the public policy is for substantial, meaningful, continuing time, that is a change in and of itself that can justify this.
There are only so many days in a week, and we're talking about, at this point, between equal parenting time and what your client has, 10% of a week, which is less than a day. And so what result would have been different under the current law? What would the agreement have been?
Well, I think the difference in the agreement is when the law changes that says that, as Governor Brewer stated when she signed this law into effect that it was to prevent lopsided custody decisions. How is my client not to know if the governor said that it'd be prior to this law going into effect there could be lopsided custody decisions? When he went into an agreement to do this, if the new law was in effect, he potentially would have agreed to
All
something.
due respect to the governor, the law is the product of the governor and the legislature, two independent branches of government acting together. We don't follow commands of the governor or rhetorical statements when she signs bills to determine what the law is.
But the law is a significant change. I mean,
Are
the
you
law.
suggesting, counsel, that the court, at the time the consent decree entered, had the law been what it is now, the court would have had to have rejected it? That it's an impermissible agreement to have reached under the law as it currently exists?
I think anything is permissible, Judge, and you don't really see courts rejecting that. But I'll tell you the difference in the tenor of the court from after this law has passed has been significant. That equal parenting time, if we go to any CLE, is that equal parenting time is basically the norm. And the standard from every judge I appear in front of in Maricopa County is when they walk into court on a custody hearing is, you better tell me why you're not getting equal parenting time. And it is a difference. But I think that also I'd go back to the fact that this change of circumstance to get us to the factors. If we look at the case like Dorman, this court in the Dorman case said that this change of circumstance, before we actually look at the factors, that is what's been described as a non-jurisdictional impediment. It's a gatekeeper function to keep out frivolous, constant filed cases. This isn't a case that's been repetitively filed on. We're talking 4 years after the fact that this case, 4 years after a decree's entered, that they come back into court for the first modification. This isn't one of the repetitive cases tried to keep out by that. We have to get to the 25403A factors because the gatekeeper function before we get to 403A is not a significantly high burden. It's an allegation of a change of circumstance that then under the Supreme Court case Pridgeon that says once you've made the allegations, we get to 25403A. And it's our position that under 25403A is where the violations occurred. And it's also our position that how could my client have known at the time that this was going to be, the decree was going to be entered into, that this level of, for lack of better words, meddling into his time was going to occur by mother. And so at the time, if he believed that his time was his time and he could do as he wants, as multiple Arizona statutes say, that during your time you have custody, care, and control of the child, how could he know that mother would try to use that against him?
Okay, hang on. Mother meddling into his time is, I take it then, that is defined as involving her in Girl Scouts?
As ridiculous as this sounds, that's the issue here.
Okay, next, and the meddling involves when she does really well in school and is part of an awards ceremony, not allowing her to go to it because it's his parenting time? That's the meddling?
Because it's his birthday. Your Honor, I think that this gets to the issue, is what can the court do? Let's take an example. If I was in a case, obviously it's outside of Arizona, but if I'm in a case in San Francisco on this, and we have an extremely, potentially biased judge, one political leaning, they might say that I'm not doing the personal growth that the judge in this case did by involving my children in Boy Scouts. They should have been in tutoring. They could have said Boy Scouts are, a bigoted organization, and that's not right. That you shouldn't put your kids in that organization.
We're talking about hypothetical cases involving politically biased judges in another jurisdiction, and you have 7 minutes and 27 seconds left. I suggest we focus on your client's case.
But that is the issue here, Judge, is that the statutes, we have 3 Arizona statutes that specifically state that during my time I have care and control. 1601, fundamental right in Arizona to nurture my children. 25401/5. It says during my time I have custody, care, and control of that child. I get to pick what I do. And while it seems one step away, we're not saying that the court can't do a best interest standard or something else. I'm saying what this court said in Granville was when you go outside of the limits imposed and impinge on a statute and somebody's fundamental rights, that's the unconstitutional part of it.
So now are we going to talk about Troxel? Because that seemed to be the focus of your brief.
Well, it is, but that's the entire issue here. The entire issue, Troxel, 25401-5, 1601, 1602, line up. Okay. During my time, I get to decide what my kids do. My kids do, it's what we get.
And that may be true. And nobody said, no court ever said anything to the contrary in your client's case. What the court said is your client had not shown justification for getting out of his agreement because there was nothing about what he wanted to do with a changed circumstance that persuaded the court that it should eliminate the agreement. That's very different from saying the court tells your client specifically the child has to go to Girl Scouts or the child can't hand you zip ties while you're doing electrical work or anything like that. You're enlisting the court's assistance to get out of an agreement, and you fail to persuade the court that you should. That's a whole different ball game.
But I think we have to
having the court micromanage parenting.
But I think that it's not. If we look at the actual findings of the court's convinced that Alexa's ability to develop as her own person would be hindered by father's unwillingness to participate in extracurricular activities, etc. This is what the court used. The court didn't use that there's no good cause to change it. The court used the vast majority of this minute entry deals with extracurricular activities. That's what the court used against him. And
That's the objection raised by your client. Your client said, I've only got 30% of the time. I can't afford to be doing the awards ceremonies and the Girl Scout events and things during my time. She can do that because she has 70% of the time. And I believe he also said, if it was flipped around, and if I had 70% of the time, then I'd put her in Girl Scouts because I'd have the time for that, which sounds incredibly hypocritical to me if you're saying, I would do what she's doing, but it would be okay if I was doing it.
Well, I think that does make a difference. If the court's going to say that during his time, during his 1 day a week, one weekday, that he has to go to an activity that mother scheduled, that's what's violative of the statute.
The court didn't say that.
Well, but the court used it against him, and the vast majority of the court's minute entry deals with extracurricular activities.
If mother had petitioned for an order of the court telling father that he had to do certain things at certain times, that would be a different kettle of fish. But that's not the case we have here. And the fact that the court takes into account the circumstances of the child's upbringing, how could it do anything else? In every other case, if the court failed to take that into account, it would not adhere to the precise terms of the statute, and we would say the court made no findings, so we can't review, and we'd remand every case.
I think the court is intending to go that far, Judge, because on page 4, the very last...
That's speculative.
Well, we have a case here.
No, we have a case here and a result and an appeal of that result. We have to decide whether to affirm or reverse a judgment. And what we think the court might have been intending to do is more akin to dictum and judicial education than the case we have before us.
And if I may, Judge, the last paragraph in that, the party shall use the parenting coordinator to determine extracurriculars. That's not speculation. The court ordered him to go to the parenting coordinator on this issue to determine what extracurriculars the child shall do. It's in the order.
Okay, and you've touched on a different issue that I know you don't have much time, but I want to address. Did the parties stipulate to a parenting coordinator?
They did.
Okay, so the parties were not forced to go to a third-party provider to make decisions about their lives. They agreed to this.
At the end of the hearing, you'll see in the last paragraph of the transcript, and then I'm going to save my time. Last paragraph of the transcript, the court says, "I think you should have a parenting coordinator." They say, "Okay, we'd agree to use Weinstock." They said we'd agree to use Weinstock. The court appointed Weinstock. So as far as the court saying we'd like you to use a parenting coordinator, and then them saying, picking a name.
But they had the freedom to object. They had the freedom to say, no, we're not going to have a parenting coordinator telling us what to do with our child. But neither one objected.
Correct.
An objection along those lines might have had great weight, but neither one did object.
We'd hold that's outside the even a parenting coordinator's authority, that outside the statute on this is your time with your child.
I would certainly agree that a parenting coordinator's authority is far subordinate to that of the court, but the objection to the court saying you must use the parenting coordinator when the parties don't object to that appointment with that scope is hard to hard to use as a basis for reversal.
Well, and I don't think the objection to a parenting coordinator itself, we always have the right to object to the parenting coordinator orders during this Rule 74 process, bring them up on appeal individually. So I think until there's an order we object to, the use of a parenting coordinator for communication thing is not object to, and I'm going to save my 1 minute.
Good morning. May it please the court. My name's Polly Rapp, and I represent the petitioner appellee and the mother in this case, Lisa Jennis, formerly known as Lisa Settle. Let me go right to the question about what the family court ordered about the parenting coordinator. I have it right here. It's the August 12th, 2013 minute entry. The judge ordered, it's further ordered that the parties utilize a parenting coordinator, Dr. Weinstock, to help improve their communication and ability to work with one another when discussing daughter's best interest, including extracurricular activities. So it wasn't just that the family court ordered them to discuss extracurricular activities. The family court was concerned about the type of communication that was going on and found that it was unhealthy on a lot of levels. The other thing I wanted to point out on the change of circumstances issue, Father made some arguments in the below. The parties briefed the issue in the pretrial statement, and Father's main position was that that there was changed circumstances for two reasons. One, his home was now stable, and number two, he wanted to spend more time with daughter. And those issues were presented to the family court below.
Okay, hang on. He wanted to spend more time with daughter was a change of circumstances?
That's one of the things he argued, yes.
So effectively, at the time the consent decree entered, it had been his interest to spend less time with daughter.
You could argue that, I suppose. Yes. I mean, the bottom line is that originally in the original parenting plan, he agreed to this specific schedule, and basically his feelings changed over time. Now that she had gotten older, he wanted to spend more time with her. The problem is that he has to show more than just a change in circumstances. The change in circumstances have to materially affect daughter's welfare, not his welfare, but daughter's welfare. And he did not show that. Obviously, he had purchased his home before the divorce decree was final. He always knew he was going to, presumably knew he was going to have a stable home at some point before he reached the 50-50 parenting time.
But counsel, did the court, in your opinion, did the court find a change of circumstances here?
It was not specifically set forth in the order, but it was supported by the record, and this court can affirm on any ground that's supported in the record. The arguments were made, they were presented to the court. It is true that the court's minute entry does not depend on that factor, but again, I would remind the court that it's not just any change of circumstances. The change in the circumstances have to affect or materially affect daughter, and nothing Father showed indicated that.
But you said it was implicit in the order.
It was not specifically mentioned in the order. What it was it was raised below, presented to the court, so it was an argument or an issue that both parties dealt with.
Did the court ever say, having found the substantial and continuing change in circumstances, I'm going to now move to the 25403 list of horribles?
No, Your Honor, no.
Okay. So there really wasn't any distinction. It was just kind of an ongoing process of the hearing.
Yes.
Okay, thank
Yes.
you. Did they rule from the bench, or did the court go back and issue a ruling thereafter?
What was ruled from the bench was that the parties should go to the parenting coordinator, and then after taking the matter under advisement, the August minute entry was issued.
Thank you.
On the issue of the best interest standard that you just raised, Father did not show that the increase in his parenting time would, again, the issue is, does it serve daughter's best interests? And he did not show that. The evidence showed that daughter's activities all take place on mother's time. He does not take daughter to the doctor or dentist or any of her extracurricular activities. He does not support her religious education and refuses to take her to Sunday school. So all he really showed is that increasing his parenting time would serve his best interest, not daughters.
Well, it would be pretty dangerous of courts to start telling parents that they have to support certain religious educations. I mean, courts really ought not get into that, should they?
The parties had an agreement, Your Honor.
I understand.
Well-
But what are you suggesting that the court should have done with the information it had?
Well, I think the court absolutely did the proper thing with the information it had, which was the court did not take away any of father's time, as the court has pointed out today. What it did was refuse to give him more time. And the reason was because the fear, I think, was that if he got more time, he would not take her to the activities that are valuable to her. Not to the judge, not to the father, not to the mother, but to her. She enjoys going to Sunday school. She needs to go to Sunday school to be able to be prepared for her bat mitzvah. Father doesn't want to take her during the Sunday time that he has. And so the judge decided that it would be better for daughter, in her best interest, that mother have more times to make sure that she can make those classes and engage in the activities that she wants to do.
Counsel, was there any distinction between the week-to-week visitation that's delineated in the pleadings and extended periods during the summer? Quite often it is the case, and I think the guidelines even lay out schedules for summer visitation that is to greater degree or greater magnitude than the regular school year visitation. Are you aware of any distinctions?
I do know that the agreement did provide for holidays. I cannot remember off the top of my head what it provided about vacations, but I think the schedule was fairly standard for most of the year. I do know that the parties each took daughter on vacation with them, and so they had an agreement. But I don't think that the vacation extended for the entire summer.
Was there any consideration of what would happen if a camp, a band camp, or a sports camp, or a religious camp fell on the other, if you will, parents' visitation or parenting time period, how that would impact on it?
I think that the parties had agreed to try to work together under those circumstances.
So what we've got is that where they recognize there's a likelihood that you can't plan that far ahead when a summer camp is going to be scheduled or when a travel experience is going to exist, they agreed that on those they'd have to alter or they would change in some fashion or they would accommodate the imposition on their parenting time, but during the regular school year when it's Girl Scouts or award ceremonies, they couldn't agree.
Well, it wasn't so much that they couldn't agree. Again, the whole entire context of this case is father requesting to have more parenting time. Now, it's true that they did have a lot of disputes about...
The objection is the violations of father's parenting time, correct? That's all I'm trying to get to. He's objecting that on too many occasions your client infringed on his parenting time.
There is no evidence that that happened.
My question is, was there an anticipation that when things were scheduled by a higher force, for instance, a band director, I don't know if the child is interested in music or not, but when it was when a band camp was scheduled on father's time, was there an agreement that in fact the child would be able to go to that, or was she just out of luck on that?
Well, again, I think the anticipation of the parties was that they would agree if it was a summer activity like that, they would treat it like vacation. But the evidence did suggest that father might not be very cooperative because, remember, the record shows there was a Girl Scout event that he refused to drop her off early for, and also, as the court mentioned, there was a party to celebrate her reading points that he wouldn't take her to. But this was not mother's petition to take time away from father. This was father's attempt to get more time. And all the family court did was say, based on the best interest of the child, that's not what I believe is in her best interest. It's in her best interest to keep the parenting schedule the way that you agreed to have it. There is no basis to change it now. On the issue of the constitutional violation, it's our position that father's due process rights are not implicated here because both parties in this case have equal constitutional rights, and in essence, they cancel each other out. In Jordan versus Ray, which concededly was a school choice case, this court held that fit parents have equal constitutional rights to raise their children and applying the best interest standard to resolve disputes between them does not usurp either parent's constitutional rights. Now, even though it was a school choice case, we would argue that the same principles apply to all disputes over parenting decisions. So it's only when you have a parent and a non-parent, like a grandparent, that are at odds over the amount of parenting time that due process principles come into play.
What if the court had said, you have to take the child to Girl Scouts, you have to take the child to Sunday school, and under no circumstances may the child assist you with electrical work? Would that be a problem? Or do you think the court's authority extends that far?
I don't think the due process clause would be implicated even in that situation, but certainly that kind of decision might be challenged as to whether it's in the child's best interests. But I still don't believe in a dispute based on the case law that we cited, including a case from this court, that when it's a dispute between fit parents about, and they're both exercising their constitutional rights, and they want to exercise each of them wants to exercise their right in a different way, there is no issue of the Constitution being violated. Somebody has to break the tie, and it's not, due process is not implicated when the family court has to do so.
Well, but if the court is there a point beyond which the court might tread into substantive due process problems if it truly started micromanaging the parenting of a child?
Perhaps you could conceive of such a case. This is not one, though, because, again, the family court, even though the family court did determine that father was not willing enough to participate in daughter's extracurricular activities to warrant more parenting time.
What if the court started choosing extracurricular activities? The child has no musical talent, and the court says, go to band camp.
Yes, I think under those kind of circumstances, both parents could then argue, well, now you're going well beyond what you're tasked with doing.
That might offend due process at a substantive level.
Yes.
Okay.
But in the situation you're raising, I just want to make sure we're clear that the family court did not tell father what he had to do on his time. All the family court did was say, because your record has not shown that you're particularly interested in taking daughter to these things, and in some instances have refused, I'm not going to increase your time. So it's two different things. It's wrong to say that the family court interfered with his right to make decisions on his time. It did not do that. Father also makes the argument that the family court was wrong in finding that his time is substantial and maximized. The fact that he agreed to the original parenting agreement at least reflects his belief at that time that his parenting time was and would be in the future substantial and maximized. He agreed to this schedule, this graduated schedule of increased time. He did not show the family court why it was he believed his belief regarding his time changed. In addition, the evidence did show that at least on one occasion, father rebuffed mother's offer to take daughter on her time.
So even if not scripted, when given the opportunity to spend more time, it was rebuffed?
Yes. I don't remember the exact language, but he said, unless we're dealing with a case of death or serious physical injury, I would appreciate it if you would make other arrangements before calling me to take daughter.
Thank you.
The other thing that's important to remember, too, is that father's parenting time now has increased to 42% since April of this year when daughter turned 10, and it will increase again to when she's 13 to 50%. And just so we're clear, mother's not arguing that this makes the case moot, but it certainly would have had an impact on the family court's decision that father's time was substantial and maximized and certainly would continue to be in the future. By any standard, father's parenting time, as the family court found, is substantial, frequent, meaningful, and continuing. Finally, we're asking that the court do what the family court did and award mother's attorney's fees in this appeal under ARS Section 25324. Father has greater resources, and in addition, prior to the hearing on father's petition, mother offered to compromise by accelerating the parenting schedule to 42%. But father declined the offer and said that he would either take equal time or nothing. So the family's court ruling should be affirmed because it did not violate father's due process rights and because maintaining the parenting time schedule that the parties agreed to was in daughter's best interest. If there are no further questions, I'll sit down and be quiet.
Thank you.
Please report. I mean, I really have nothing else on the change of circumstance. The court didn't find it either way. There's nothing for me to argue. I can't imply the court did it or did not. What I have is that a 403A factor where the court used his choice of activities against him. And that's what our position is, that on the specific findings that the court itself used a factor that it cannot. I would state that in mother's own words, she absolutely believes the court can order the child to do activities on father's time. Page 81, more time with father is taken away from activities, mother's statement, and when asked whether the court should order activities to be done on father's time, mother said yes.
Okay.
It is that, so we believe that based on what is actually in writing, that the court used an illegitimate factor, which is infringing on my client's constitutional right to parent and to raise his child as he sees fit. Him seeing fit is what you do on a day-to-day basis. It's every single activity you choose for your children, whether it's watching a movie, choosing to take them to Girl Scouts or not. That's his right. Whatever he wants to do on his time is his choice. If we get the court into stating this is a better activity than that, that's the slippery slope, and that's what's happened here. The court didn't like what activities he refused to, or the court liked what activities that my client refused to take him to. That's judging an activity.
Okay. Thank you. Thanks to both counsel for helpful arguments. The matter is now under advisement. We'll issue a written decision in due course, and we stand adjourned.